welcome to Legalese, our humble attempt to decode legalese for you. Now this week saw many developments, but it is pertinent that I wrap up the highlights for you. Under scanner this week are: number 1, legislators who create ruckus cannot claim parliamentary privilege, says Supreme Court in Kerala Assembly vandalism case. Number 2, children taken to anti-CAA protest sites. Instances of child sexual abuse unreported at Harsh Mandir's children's homes. Number 3, personal information having no relation to public interest cannot be disclosed under RTI Act. Number 4, people being hung from trees in West Bengal, state victims of post-poll violence. While rejecting pleas by the Kerala government and ruling Left Democratic Front seeking permission to withdraw cases against prominent leaders from Kerala for vandalism in the Legislative Assembly, the Supreme Court said that legislators who indulge in creating a ruckus cannot claim parliamentary privilege and immunity from criminal prosecution. Now, this incident dates back to 2015, when some prominent leaders of the CPI and CPI Marxist, including the present Education Minister of Kerala, were found disrupting the Legislative Assembly while the budget session was being conducted. Cases were registered against the leaders, and though an application was filed by the public prosecutor before the Chief Judicial Magistrate at Trivandrum, the same was rejected. Kerala government approached the High Court challenging this, but the court confirmed the magistrate's decision of disallowing the applications to be admitted. Present appeal is against the High Court's confirmation in March this year. Supreme Court observed that acts of destruction of public and private property in the name of protests should not be tolerated. And though members are required to stay true to their oaths and immunity is to help them discharge their functions freely, destruction of property cannot be regarded as essential to carry out their functions, and it cannot be seen as part of rights and privileges. Top Court thus junked each of Kerala government submissions one by one and affirmed the High Court order. National Commission for Protection of Child Rights informed Delhi High Court that 2 children's homes associated with Harsh Mandir had prima facie gross violations of the Juvenile Justice Act and that they needed to be further probed. Now, back in October 2020, inspections were carried out at these homes, which are run at behest of an organization, Center for Equity Studies, of which Mandir is the director. He sought quashing of the inspection reports. Before Delhi High Court, NCPCR had filed an affidavit as directed by court, detailing aspects of the alleged illegalities at these homes. NCPCR recorded some discrepancies with the management of the said homes, treatment of children in the homes, as well as the untraceable sources of funding which, according to the NCPCR, the institutions have been reluctant to reveal. The Commission also told court that children were being taken to anti-CAA protest sites on the pretext of goodies, rooms of dorms were neither well lit nor ventilated adequately, foreign nationals continually visited the homes, and only children from a particular religion were housed there. Instances of child sexual abuse went unreported. The Delhi High Court has said that under the Right to Information Act, personal information which had no relation to any public activity or interest and a revelation of which could cause unwarranted invasion into the privacy of an individual cannot be disclosed. The bench was hearing an appeal against an order which had earlier dismissed a writ petition. The petitioner had originally challenged an order passed by the Central Information Commission against the response of the Presidential Secretariat to an RTI application seeking information in respect of certain appointments made for multitasking staff at the Presidential Estate, Rashtrapati Bhavan. So essentially, the division bench of Delhi High Court has now upheld the order of the single judge bench, which said that the information sought in respect of the names of the fathers and residential addresses of the candidates is completely invasive and would be a roving and fishing inquiry. Court also said that the petition was quiet about the fact that the petitioner's daughter had applied appointment for the post of multitasking staff at the Rashtrapati Bhavan, and that the petitioner seeking the requisite information, especially after his daughter did not obtain employment, clearly pointed out to some ulterior motives. People are being hung from trees. If your lordships think that there is still no urgency, then I have nothing to say, said Advocate Priyanka Tibrawal in the cases concerning West Bengal post-poll violence before Calcutta High Court. The advocate represented victims of the post-poll violence. State of West Bengal appeared before the bench and told court that they had received another supplementary affidavit from the NHRC, which ran into 900 plus pages, and that they needed more time to file a reply to it. Counsel representing victims strongly objected to this demand, to which court said, "What is the urgency? Why can't the hearings wait for a week?" Senior advocate Mahesh Jethmalani said that in cases of this kind, time is of essence, simply because evidence needs to be preserved. There should be minimum delay in such cases or no delay at all, he said. Counsel for West Bengal refuted this, saying that the court was not a place for emotional fervour. Eventually, the court took on record autopsy reports of Abhijit Sarkar, a BJP leader who was killed allegedly at behest of TMC goons in the violence that engulfed the state after polls. Court also granted more time to the state to file a reply, that is by July 31st, and said that it will now hear arguments on August 2nd. Thank you for watching. Please don't forget to subscribe to our YouTube channel and to hit like to this video if you found it insightful. See you later.